Hello, my name is Emily Hendrickson, and this is my written assignment overview. I titled it An Analysis of Jurisprudence and Its Influence on Procedural Law. So let's start with a little introduction about what we are going to be talking about. So jurisprudence is the theory or study of law that focuses on its nature, answering foundational questions such as why and how it was created. Jurisprudence is highly relevant in the American legal system because it shapes how judges interpret laws, how lawmakers author statutes, and how attorneys construct their arguments. So my thesis statement for my paper was the philosophical foundations of jurisprudence shape the rules and procedures that govern American legal cases, and these influences are evident across each phase of litigation and in the actions of the court employees responsible for enforcing them. So there are many schools of thought, but the three that we are going to be focusing on are natural law, legal positivism, and legal realism. So natural law holds that the law is rooted in morality, which are principles concerning the distinction between right and wrong or good and bad. Examples include the concepts of murder, theft, fraud, respect, and kindness. So these are what are deemed to be good or inherently evil. Legal positivism claims that law is legitimate and valid by recognizing it comes from governmental authority, thus straying from the necessity of morality. In other words, legal positivists recognize a law as valid only if it comes from a higher authority such as the courts or other government agencies. Legal realism views the law as a tool used to achieve social ends, emphasizing the results of its applications in the real world. So the core points of my paper, there were three core points. First was comparing civil and criminal case procedural steps. Second was the application of jurisprudential principles by legal professionals. And third were how appellate courts address jurisprudential questions. So first was comparing civil and criminal case steps. So the purpose of a civil case is it aims to settle a private dispute between two parties, often ending in financial compensation for any wrongdoing. The purpose of a criminal case is it brings a defendant before a governmental body for crimes against society. So a civil case, the steps, they start from a complaint and then they end in a compensation. So first is the initial complaint, second is answer, third is discovery, and then fourth is the settlement discussions. And then if the case proceeds to trial, it then goes over a jury selection, if applicable, opening statements, a presentation of evidence, closing arguments, and then a verdict announcement, but typically the verdict is someone is deemed wrong, or they've done a wrongdoing, so it's financial compensation. It's not like a criminal case where they are sentenced to prison or something. So then the steps for a criminal case are, it begins with an arrest, then arraignment, then discovery phases, motions, and pretrial conferences. If the case proceeds to trial, there's then a jury selection if applicable, opening statements, presentation of evidence, closing arguments, and verdict announcements. So as you can see, the civil case and criminal case, once it gets to trial, they're pretty similar, except for the notable difference is that a civil trial simply results in restitution or financial compensation for the civil wrong, whereas a criminal trial results in a sentence of imprisonment or other judicial consequence for breaking the law. Similarly, a criminal trial, once in process, proceeds until a verdict is reached, whereas a civil trial can be halted at any time if a settlement is agreed upon. So how natural law influences trial procedures. Natural law jurisprudence highlights the innate rights of citizens, influencing each stage of trial procedures by requiring the court to uphold constitutional standards such as due process, fairness, the presumption of innocence, and the right to an impartial jury. Legal positivism focuses on formality, referring to the proper use of the law. Thus, legal positivism influences procedural law by providing the framework for how all legal proceedings, including trials, operate in ensuring consistency with predictability within the judicial system. Legal realism, on the other hand, influences procedural law by allowing judges to exercise discretion in interpretation, promoting the idea of adaptive law. Legal realism is viewed as flexible, whereas legal positivism is regarded as more rigid because it's concerned with structure. Next, we have the application of jurisprudential principles by legal professionals. So there are many people who keep the court system running, but we are going to focus on these three. So first, judges serve as unbiased moderators in court proceedings, hearing trials and arguments while ensuring proper procedures, as outlined in legal positivism, are followed, and that the emphasis on the constitutional rights of citizens, as outlined in natural law, is upheld. Wendell claims that a judge's most essential quality is remaining impartial, and that the judges who imply impartiality in their rulings enforce the court's goals of fair trials and unbiased justice. Attorneys or lawyers act as the court's advocates, presenting arguments for the public. As seen in the previous slide, there are multiple stages within each civil and criminal case. Legal positivism views formal structure as a way of ensuring fairness and predictable justice. Thus, attorneys follow procedural steps such as discovery phases and disclosure duties to maintain accountability and reduce the risk of bias. Court administrators are kind of different. They are responsible for overseeing and managing a court's operation, essentially dictating what a court's day looks like, and implementing the structural values found in legal positivism. Although they do not directly shape the law, their position and responsibilities allow legislative and judicial bodies the time to discuss legal questions. And then lastly, we have how appellate courts address jurisprudential questions. So to begin with, they start by weighing all schools of jurisprudential thought. And then each school of thought gives interpretive tools. So legal positives look at statutory language, natural law advocates consider the moral background of the law or case, and then legal realists examine the social and future implications. And then there's also an importance you have to consider the justice's background and expertise. For example, Schiff argues that the inherent biases and jurisprudential values of the Supreme Court justices unconsciously bleed into their decisions, even though they are supposed to remain impartial. And then here is my conclusion. Jurisprudence is not without critics. Simply put, jurisprudence often lags behind society in terms of currency. Critics such as Judge Posner argue that some justicability doctrines, such as standing and the political question, are outdated, short-sighted, and, quote, do not serve the policies it is often said to promote, unquote. This shows just how subjective jurisprudence is. After all, it is just a theory and thought processes, not factual science. And then I did like a little comparison thing. So just as American society is described as a melting pot of culture, thousands of legal minds contribute various ideas, values, and beliefs to the law's construction, which is continually reshaped by new legislation and judicial interpretation, including new expanding jurisprudential philosophies like experimental jurisprudence, which aims to integrate scientific methods and psychological data gathered through surveys designed to measure the public's perception of legal concepts. My concluding statement was jurisprudence is a crucial component of the legal system, helping to maintain balance and efficiency by defining procedural frameworks, facilitating the judicial interpretation of statutes and cases, and supporting attorneys in preparing compelling arguments in court. And then here are my 4 references. Thank you very much.